Hello, everybody, and thank you for coming. I'm Jennifer Granick, and it's so great to have people here. I see so many friends out in the audience, and I'm eager to hear your thoughts and responses about the work that we've been doing. I'm going to try to talk a little shorter than I might have anticipated so that we can leave some time for questions and comments. So let me talk a little bit about some of the work that Riana and I have been doing this year for the Crypto Policy Project. We all know that the internet proliferates data about us. And we're learning the extent to which our offline movements are also tracked and recorded by surveillance cameras, by our cell phones, by facial recognition technology. And we're all anticipating how this tracking and recording problem is going to get worse with the Internet of Things, which somebody on Twitter the other day called the Internet of Things that should not be on the internet. A collection of devices that can record our heartbeat, how far we walk, what our refrigerator has in it, how often we order ice cream, and those sorts of things. The ice cream thing is a personal problem for myself. So how do we protect all this data? There's all this data out there that is valuable but can also be abused. How do we roll this back and protect some of this data? And we know that protecting the data is important because we see so many security breaches happening at the same time. I mean, I'll name just a few. The Office of Personnel Management breach, the Democratic National Committee breach for email, the recent Yahoo hack. When information is located someplace, there's people who want to hack in and grab it. So if there's so much information that's generated and insecure, how do we regain control over at least some of that data? And the answer is encryption. Encryption is the way we do that. So particularly after the Snowden revelations, there was a really concerted effort to try to encrypt more information to keep it secure. And that should have been happening anyway with the breaches that were going on. But this increased push for encryption has created a policy conflict. And the policy conflict is between the knowledge that encryption can secure information with the knowledge that encryption can interfere with legitimate law enforcement investigations. So there's this clash of views, and this isn't new. We've been here before in trying to figure out what are we going to do about this reality. In the 1970s, as the use of encryption moved from governments to private industry, there was a battle over key length and how long encryption keys should be and what would be secure enough that an advanced, well-funded nation state could or could not crack it. In the 1990s, as encryption began to move from private industry to individuals, there was this battle again over whether things like smartphones should have encryption in them that the government couldn't break, or whether we should push an architecture for key escrow that would ensure that the government could access information if it wanted to. And in each of these cases, the debate was resolved on the side of strong crypto, right? It's been the progress of the crypto wars. And this is because of really a consensus on the part of technologists that security is hard, that we're not doing a really good job there, and that we need strong crypto. If we don't have strong crypto, we are creating more security problems for us. So this is important to stand up for. Yet today, here in 2016, we are facing what we've been calling the third crypto war, which is this policy battle over what are we going to do about encryption. So the policy battle has initially focused on the idea of legislated backdoors, where it would be unlawful to deploy crypto systems where there's no wiretapability, where the provider can't provide plain text or the government doesn't have the ability to decrypt. And the legislated backdoors avenue as a policy matter doesn't really seem to be getting super far right now. And I think that's because there is this technological consensus that strong encryption is a good thing, as well as the physical reality, which is that if we don't manufacture products with strong encryption in them here in the United States, somebody else in another part of the world is going to do so, and so we'll just be basically shooting homegrown industry in the foot without actually denying anybody the ability to completely obfuscate what they're up to. So what we've seen in encryption policy is what I'm going to call encryption workarounds. And these workarounds have taken a couple different forms. So one preferred workaround is the issue of government hacking. So if we say there's no backdoors, governments, law enforcement will want to go to where the data is stored in plain text, and that's the endpoint device. It's your laptop or your cell phone. Should government agents be allowed to hack into these endpoints and access data there? I mean, we know this is something that's happening now. A number of renowned technologists wrote a paper called Keys Under Doormats, which is about this issue, and saying, like, you know, that government access to endpoints under some circumstances may be a better policy decision than encryption backdoors. We are exploring that issue here at the center. In conjunction with Mozilla, we have been organizing a series of conversations about legal and technological issues associated with government hacking. Last week we had one on a change to federal criminal procedure that allows magistrate judges to issue out-of-district warrants for remote searches of computers where their location is hidden, or if there's 5 or more involved in a CFAA offense, a Computer Fraud and Abuse Act offense. On November 16th, we're going to do another one on the issue of vulnerability disclosure. When should the government disclose vulnerabilities that are in its possession so that providers and manufacturers can fix those vulnerabilities, versus the government keeping or hoarding that information so that it can be a more effective attacker when it's doing government hacking. So we're exploring in depth these legal issues here. Another encryption workaround is the problem of compelled decryption. Very recently, a warrant issued, and the warrant said that anybody who's on the premises when this warrant is executed is ordered to put their thumbprint on their phone or their iPad in order to decrypt the information that's on there. And the question is that a valid order? Does it violate the Fifth Amendment? Is it a legitimate exercise of the warrant authority? Does it differ if you put your thumbprint on the screen as opposed to give your passcode or something like that? And how does the Fifth Amendment right against compelled self-incrimination play into this issue? But the one encryption workaround that I'm going to talk about today with Riana is the issue of technical assistance from providers. Both compelled, and this happens both compelled and voluntary. And when we started this project, my instinct was that how can we talk about encryption policy when we don't really know what's actually being done today to circumvent encryption? We need to know more about what's really happening. And the reason we don't know is because these decisions about how companies are compelled to assist government in surveillance are made in secret. And we don't know what those decisions are, and we don't see what they are. We sometimes see little glimpses when a company decides to push back and if a court decides to publish an opinion. But otherwise, we don't really know. So traditional technical assistance is not that big of a deal. Law enforcement goes, it obtains a court order ex parte, meaning only the government appears in court, no one else is there. An order is signed by the judge or magistrate, and the order will say that the provider or some other person has to provide technical assistance. This usually happens under either the Pen Register Statute or the Wiretap Act. The government takes that and then delivers it to the company, the provider. The provider's served with and reviews the order, and if it's a phone company, traditionally the phone company has an interface for the phone data that is capable of electronically delivering either phone numbers dialed or the contents of phone calls, the actual audio, over a leased line to a secure law enforcement facility. The internet version is that if you're a company and you hold the data in plain text, or if you're capable of decrypting it, then companies have generally been doing this as long as government gets the appropriate legal order to compel the disclosure of the information. There are some exceptions here, but I'm not going to get too into that. And this has been happening pretty routinely. And it's been happening under the wiretap and the Pen Register statutes, which generally say that a provider or person shall provide all technical assistance necessary to accomplish the surveillance unobtrusively and with a minimum of interference with the services. So the legal question that we have is, what does that mean? What's the extent of that compulsion? Is it okay under these statutes to force companies to decrypt data that they don't hold, as in the Apple versus FBI case? Is it okay to force companies to write new software that circumvents security measures? How about to turn on the microphones or the video cameras in your devices, your smart TV or your Amazon Alexa or your cell phone? Can companies be forced to disclose their private encryption keys even if turning that key over would expose the information of all the users of that service to government surveillance and not just the target? And can companies be forced to build in backdoors? Some people may remember that there were, in the Snowden documents, some disclosures that Microsoft had made changes to Skype to enable government surveillance. And Microsoft, when asked for a comment on this story, said, there are things we're obligated to do under the law that we wish we could tell you about and talk more about. What are those things, and how can we really make informed encryption policy if we don't know what's happening right now? Okay, so this was the idea behind getting the money from the Stanford Cyber Initiative and why we hired Riana. So the week Riana started was the week that Judge Orenstein in New York issued an order asking Apple to respond to an important question. And Judge Orenstein wanted to know whether this law called the All Writs Act could be used to compel Apple to decrypt data on a phone that it manufactured, but it didn't have any control over. It was already sold to somebody. Now, the All Writs Act was passed in 1789, and it says, the Supreme Court and all courts established by act of Congress may issue all writs necessary or appropriate in aid of their respective jurisdictions and agreeable to the usages and principles of law. This is a pretty broad law to be making these complicated assessments about whether it's a good idea to force companies to decrypt data. What does that mean for privacy, and what does that mean for security? Yet this was the law that the government used. It was a search warrant plus the All Writs Act, because the Pen Register Statute and the Wiretap Act didn't apply to this kind of search. So we participated with EFF. I see my EFF colleagues there. With EFF and the ACLU. I don't see my ACLU people, but if you're here, shout out to you guys too. In writing an amicus brief that argued that this interpretation stretched the All Writs Act too far. That the government couldn't force companies to do things just because they manufactured the device. That was beyond what it allowed. And ultimately, our brief was not accepted. The court said, no, I'll just listen to what Apple said. We'll decide the case based on this. But in the process of this litigation, we learned some interesting things. And one of the interesting things we learned is that Apple had done this unlocking 70 or more times in the past based on this All Writs Act argument. An argument which Apple nevertheless said was not legally sufficient to compel it to comply. So, we have this request. Apple's been doing it, but they can't be forced to do it. So what's going on here? It was interesting because in the course of the oral argument of this case, Judge Orenstein asked the government, why are you pressing so hard on this issue? This is an early version of the iPhone. But later versions of the iPhone are technologically different. For the later versions of the iPhone, on this iPhone, the decryption key is something that Apple has or can generate. In later versions of the iPhone, the encryption key is something that's tied to the user's passcode, which means that Apple can't generate the encryption key. Nobody can unless they know what the user's passcode is. So why does this matter? And in the oral argument, the attorney for the government said, well, we think that the authority we're asking for here goes beyond asking Apple to do what it can do now. We think we could also use this authority to ask Apple to do stuff it's never done before. And sure enough, the next February, we had a case that dealt with exactly this issue. It involved the San Bernardino shooters, one of their phones, one of the iPhones, and this was the more advanced version of the phone. So it has a passcode lockout. If you misguess the passcode too many times in a row, then you're blocked out of the phone, and also there's a delay, so you can't just keep guessing. So it was interesting here because there was a very different magistrate approach in the San Bernardino case as compared to how Judge Orenstein approached it in the New York case, even though this was a far more aggressive application of the All Writs Act. In this case, the magistrate issued an order saying Apple had to do it. And then Apple had to come into court and say, hold on, wait a minute, give us time to brief it. We want to explain to you why we shouldn't have to do it, and put Apple in that position of asking for more time. For those of you who are lucky enough to stay for the entirety of this program, Judge Smith and Paul Graywall will talk about this issue and the approach that magistrates, the magistrate bar, the challenges that the magistrate bar faces when confronted with these kind of novel surveillance demands or requests, and the different approaches that magistrates have taken in trying to deal with these and figure out what's the right thing to do in this situation. So, you know, the legal arguments were out there about how could this All Writs Act be the thing that was going to enable you to force Apple to, basically what they wanted Apple to do was to create a version of the software that disabled the passcode lockout so that the FBI could brute force guess the password without erasing any data on the phone or being locked out. And there was Apple and others to make the legal argument about why the All Writs Act didn't contemplate this. But you know, we thought about this and we decided to think about it from a security perspective. Like, you know, we've been talking about how important encryption is and how encryption workarounds create security, vulnerabilities, and put people at risk. Was that true for this order as well? So we went to our colleague in the computer science department, Dan Bonet, who's an applied cryptographer, and we asked him this question. And we went to some friends of mine from the hacker world, experts in iPhone security and iPhone hacking, and we said, you know, what's the answer here? So, you know, the legal question was, can you be forced to create new software that doesn't currently exist to carry out a capability that Apple doesn't currently have? In our approach to our amicus, our argument was, can you do this without creating security risks? And what the experts said pretty uniformly is that backdoors pose security risks and that these security risks can be pretty serious. This is something that might not be obvious to a magistrate judge sitting on the bench, deciding these cases. It's not something that the All Writs Act mandates that the court consider, even though it's obviously very important. It might not have been something that Apple seriously wanted to argue. If you do this, our phone isn't going to be secure. But it was something that was true and was really important. Creating this software would be at the detriment of the security ecosystem of iPhones everywhere. So in our brief, working with our experts, we argued that forcing device manufacturers to create these kinds of forensic capabilities for US investigators would create security risks. Other investigators in the US would want access to the software. Eventually, foreign governments would want access to the software as well. Hackers would be very interested in getting their hands on this capability and would try to basically phish Apple employees into clicking on links that would give them access to the Apple system in order to get a hold of this, and then there was this added issue that to run the software on a non-jailbroken phone, Apple would have to cryptographically sign it, which if you can force companies to cryptographically sign software, it would undermine the public trust in security updates overall. When you get a signed update that says install this for your better security, but there's a chance that it's not for your better security, it's actually for your worse security, and it's taking away security measures that you were counting on, people wouldn't update, and that also would be bad for the security ecosystem as a whole. So we're very proud of this brief, and we felt like it presented an issue that not just that this judge should consider, but really as a policy matter that judges should be considering, which when we're talking about technological assistance, which is, does the surveillance assistance requested have any greater security impact for the users of that product or for computer users more generally? We're really proud because Neil Katyal, who is the former Solicitor General of the United States, person who appears before the Supreme Court on behalf of the United States, wrote us a really nice note in which he said that he thought that our amicus, of all the ones that he read, was the best one, so we were very happy about that. But we also feel like we introduced something that was very important, but is not being talked about enough in the encryption debate, which is this technological security issue. And we hope to get people who are deciding these policy issues, the magistrates, and ultimately, if it goes to the legislature, to understand the security issues in a pretty basic way. And we hope our brief accomplished that. Now, ultimately, again, we didn't get a decision on the case in the San Bernardino thing either, because it turned out that the FBI decided to pay over $1 million to get a third party to crack the phone instead of waiting around for a decision from the district court. So we still don't know the answer to these questions, as well as the answers to some of the other questions that I posed earlier. In our attempt to find answers for these questions, Riana is going to tell you what approach we've been taking there.
All right. Thank you, Jennifer. I'm Riana Pfefferkorn. I'm the Cryptography Fellow at CIS. Turned out to be a really interesting year and much more headline-grabbing and topical of a focus area than I think any of us really thought. So what I'm going to talk about today is the Crypto Policy Project's open government work. That includes our Freedom of Information Act requests and our latest accomplishment that we had in the works for most of this year, and which was a primary goal of my fellowship coming into it a year ago, to try and gain greater transparency into the courts and greater insight into law enforcement's efforts to subvert or circumvent encryption through technical assistance measures. So to start off with, under the Freedom of Information Act, or FOIA, there's presumption now of transparency into the operations of federal government agencies on the principle that, as Severus Snape once said, you might be up to something, and that the public deserves to know what the government has been up to. So over the past year, we've filed several FOIA requests to the Department of Justice and some of its component agencies, such as the FBI. Our FOIAs seek records from the DOJ and those components to learn more about how they interpret technical assistance provisions in various federal laws and how they've been trying to get technical assistance from companies to circumvent encryption. So the first FOIA request was one that we filed jointly with the ACLU at the end of last year to ask the DOJ to hand over the case numbers and records from the 70-plus times that they told the court in New York that they'd already gotten unlocking orders issued to Apple. We filed a second request this spring asking DOJ for its internal guidelines about the issuance of technical assistance demands, records about how they're interpreting U.S. surveillance laws, why they think the laws authorize these demands, and about the times that they've gone to court seeking technical assistance, or what demands that they've made privately to companies outside the court system without any sort of judicial review, just directly to technology companies that they're interested in. And more recently, over the summer, we filed our third FOIA request to ask DOJ for records underlying the handful of instances in the past couple of years when investigators reportedly encountered encryption when carrying out a wiretap that they had had authorized by a court. So for some background, the federal courts put out an annual wiretap report every year with statistics on what kinds of wiretaps were authorized around the country in that past year. And for each district, that means how many wiretaps were authorized, by which judges, what crimes were involved at stake there, what kind of communication was being wiretapped, was it a phone call, was it an email, et cetera, how many days was the wiretap up, and so on. And by law, in the annual report, the federal investigators have to report the number of wiretaps where they encountered an encryption and whether they were able to get plain text. But that's all that they have to say with regard to encryption in particular. So there's still some open questions. What kind of crime was involved? Was it something serious, like child pornography or terrorism, which are the two of the four horsemen of the infocalypse, as they've been called before? It's hard to say. Or, as I think personally is more likely, was it for low-level drug offenses, which tend to be the most common type of federal crime that you see being prosecuted in the federal courts, and which I think would be the main beneficiary of efforts to circumvent encryption or codify backdoor access into law. And we also don't know from the wiretap report what kind of wiretap was it. Was it for emails? Was it for text messages? In an age when there's a lot of competition among different types of encrypted messaging apps, are those actually having an impact? Which apps are actually implicated in wiretap requests to the courts, and so forth? We'd love to know which service it was, how the government obtained plain text in the cases where they in fact did. Did that involve compelled provider assistance, and what exactly did that assistance look like? So our most recent FOIA is asking for the court records that underlie, really, it's only about a dozen cases over 2 years of encryption coming up in the course of the wiretap, because we want to evaluate the claims that federal officials have repeatedly made that they're going dark because encryption is eating up their ability to prosecute criminals and terrorists, but we don't know if that's really actually true. The fact that there's been so few wiretaps where encryption was encountered, and that in a lot of those there was plain text obtained, suggests that maybe, at least in the wiretap context, encryption isn't as big of a problem as it's thought to be. There are other conclusions that you can draw from that paucity of information, but we'd like to see the underlying records from those cases so that we can see what we can learn about the context where police are encountering encryption in wiretaps, what services or apps are involved, and whether we can find any patterns that emerge. So that's a quick overview of our FOIA work. I wish I had more to report about the FOIA requests, but they move at about the same pace as like glaciers move or continents drift, so we haven't really had anything come out of that just yet. If we get into litigation over that, I hope to have something further to report at our second anniversary event next year. But anyway, that's our FOIA work. So I want to talk about our litigation work to get court records unsealed. The high-level idea of the petition to unseal that we recently filed in federal court is that in this project we want to file petitions in certain select federal courts asking them to unseal the records relating to surveillance matters where the government wants outside parties' help to monitor a target. And if that sounds kind of similar to our FOIA work, it is related. You basically can't FOIA the federal courts with certain really narrow exceptions, so the proper channel for getting courts to open up sealed court records is to move to unseal them. And members of the public and members of the press have the ability to go to court and ask for this. But finding out about technical assistance cases in the federal courts is a big project. There are almost 100 federal district courts around the United States. We can't file in all of them. We had to pick a few and figure out where to start, so we decided that it made the most sense to start close to home. We already practice here. There are a lot of tech companies in the Bay Area that we think might be the kinds of outside parties whose assistance the government might seek. So we filed our first petition to unseal in San Francisco in late September. And in that petition, we're asking the courts to unseal records that show how law enforcement uses the courts to dragoon third parties into providing technical assistance in conducting their investigations. We're trying to get any records where there isn't still some need for secrecy. We're trying to exclude ongoing investigations. But our request covers the last 10 years, and so there should be a lot of investigations in there that are over and done with, and where these records can safely be made public with redactions if necessary to protect any sensitive or personally identifying information. So when we talk about third parties getting compelled to assist in investigations, as Jennifer mentioned, they're not suspected of any illegal activity themselves. They're not directly involved in a court case, but they provide a product like a smartphone or a service like email or messaging to a surveillance target. And in particular, we're really interested in knowing whether companies have been compelled to undo or circumvent the crypto in their products and services, whether they've been forced to change their encryption designs or to hand over their private encryption keys. We saw an example in the San Bernardino case that Jennifer mentioned of a dangerous and unprecedented demand to Apple to undermine its own security that would have had ripple effects for the entire security ecosystem. And initially, the magistrate in that case went along with it, and just given the papers that we've been able to see in the case, there's not really any sign of skepticism or further inquiry at the order that the government drafted that she was being asked to sign, and in fact initially did sign. And we know that that wasn't even Apple's first rodeo when it came to being help law enforcement get into encrypted iPhones. Jennifer discussed the New York case where we learned that there are at least 70 prior court orders just to Apple and just to unlock iPhones. And we know that Google gets these sorts of requests too for Android phones. And so we're curious what other cases might be out there with other kinds of technical assistance asks. In the age of the Internet of Things, that could look like turning on a microphone and an Echo or a smart TV and using it to wiretap people in their living rooms. It could mean giving police a video stream from the camera in a Nest Home thermostat And so with everything from refrigerators to toothbrushes to feminine hygiene products getting the Internet of Things treatment, you can imagine the possibilities. But we shouldn't have to just imagine what's happening. We don't really know. We don't know a lot of just facts about what the courts have been doing, what sorts of third-party demands for technical assistance the police are asking for, what the legal arguments are that they're making to justify these demands. Are courts actually going along with them? Do companies get to have any say in court to try and weigh in on the demand? And that's because mostly these cases happen in secret. It has to be filed in secret initially to not tip off the target, and that's totally valid. And then the resulting order is secret too, for the same reason. And then the files in the case are sealed, so we can't even know that these files exist. The San Bernardino case was unusual because it was filed in public by the government, not under seal. It's a decision that turned out to sort of backfire on them, but that was their decision, and I think the public weal came out the better for it. And in the New York case, that 70+ number came out during a court hearing, but the government had initially filed that demand to unlock a phone under seal, and it only came to light because of Judge Ornstein's decision to issue a public opinion questioning the government's asserted authority and asking Apple to weigh in on the legal and the technical issues involved there. So overall, these technical assistance demands are what Donald Rumsfeld would call a known unknown. We know that they happen, but there's a lot that we don't know. And there may be an entire secret body of law out there that governs these sorts of demands that we don't know about. And that's not okay. As encryption becomes more and more ubiquitous in our devices and communications, and as more of our built environment, even in the most intimate sphere of our homes and even our bodies, becomes connected to the Internet of Things, we should know whether the companies to whom we're entrusting so much about ourselves are being forced by the police and the courts to violate that trust, and whether they're even getting the chance to fight back like Apple did in San Bernardino. And beyond all of that, beyond just our need to know how the devices that we let into our lives are getting used to monitor us, we do have in our democracy a fundamental right to know what the government is up to. The police are part of the executive branch, the courts comprise the judicial branch, and they're accountable to us. The courts are a public institution doing the public's business, and since the birth of this country, there's been a presumption that with only very narrow exceptions, the public has a right under both the common law and the First Amendment to access court proceedings and records. And that's necessary for oversight of how well the police are carrying out the duties that we've entrusted to them, and how well the courts are acting as a check and balance on the police power. So that independence is crucial to our tripartite system of government. But we don't know if the courts are questioning the government's assertion of authority, as in the New York case, or whether they're rubber stamping police demands, like the San Bernardino judge initially did. But we need to know how the courts are interpreting the laws of the land, how law enforcement is exercising its duties, and what tech companies are being forced to do to monitor their users, that's us. Transparency is also necessary for another reason, which I'm really involved and invested in as an attorney, which is that it gives the courts legitimacy as a democratic institution, as our honored guest, Judge Smith, has persuasively written. Secret courts and secret laws are anathema to our tradition, and the public has to be able to know what the law is and to see how it operates. As the Lord Chief Justice of England between the two world wars once said, justice must not only be done, it must be seen to be done. And when it's not, the public's trust in this branch of government erodes. And honestly, our courts are having a hard enough time as it is in the United States without further loss of trust. So all of these values are frustrated when courts keep their records secret indefinitely. And as I said, there are certainly situations where surveillance orders and so forth are kept under seal while there's a need for secrecy, but when it's over, when the police have got their man or decide to call off the investigation, then those records should be opened up, but it's not what happens. And the way that the infrastructure of our surveillance laws are set up, the laws require ab initio that the surveillance orders have to be sealed, but they don't dictate a time frame for unsealing. And courts generally don't have processes in place to follow up and make sure that records get unsealed eventually. And so important court documents to which the public is entitled languish interminably in secret. Judge Smith has written extensively about the troubling growth of this phenomenon, and I'm hoping to hear more from him about this subject during his keynote conversation later today. And it was really his critique of court secrecy that was an inspiration for us in our project to get these surveillance matters, and especially technical assistance orders, unsealed. As far as we know, our petition is one of the first of its kind in the whole country. You see a lot of motions to unseal particular cases or particular documents within particular cases, but not so much district-wide across a whole swath of different cases. There's another case pending in federal court in DC, filed by a journalist named Jason Leopold that seeks the unsealing of a particular subset of surveillance orders. And he's had some success in kicking off a process for the court to start unsealing its files. That's good news for us because it means that we're asking the court to do something that's a lot of work. And so here we'll be able to point to another pending case where the court and the government recognize that these records don't need to stay sealed forever and where they've started a process to kick that off. Here in our Northern California case, we're not just asking the court to unseal its surveillance records, we're also asking them to enter them into its system in the first place, because when I was preparing to file the petition, I went over to the court in San Francisco, and one of the deputy clerks there told me that the court doesn't even log surveillance orders or search warrants in its case management system, so not only are they sealed, they're all in paper files in some room somewhere in the courthouse. And that's not really how the court treats most of its other papers. Nearly everything else that's filed in court gets put into the court's electronic filing system, which you can use, anybody can use, to look up a case and see what's happened in it, what documents have been filed, what the outcome was. It's not a perfect system. There are a lot of frustrations in using the federal court's electronic case management system, but being able to look up federal cases online is a really important component of public access and public participation in our government in the 21st century. And so if it's true that the court doesn't even keep a searchable electronic database of surveillance matters like it does for its other business, that's just one more way that the public is deprived of access to court records. And so that's why, in addition to seeking unsealing, we're asking the court to reform its practices and start keeping better track of its records. I'm really excited about this petition. As I said, we've worked on this for months, and it represents our best efforts to tell a really compelling story to the court about why the public deserves access, why we need public oversight of law enforcement, why there needs to be better public involvement and investment in the institution of the courts, why people need to know what the companies to whom we entrust our digital lives are, what they're doing with that trust, and about the big debate happening lately around law enforcement and encryption and surveillance more generally. So we hope that the narrative that we've told will inspire the court to want to improve the level of service that it provides to the public, even though procedurally that entails a really daunting task. And if we succeed, we'll have made a big difference for court transparency. The Northern District of California covers 7.5 million people. It's the home of the tech industry, including a lot of the companies that administer our digital lives. So there's a good chance there's some really interesting stuff in there. And this court is really influential among the 94 federal district courts around the country. So our hope is that success here will provide a model for us or for other organizations to go to other courts and try to achieve the same goal. Eventually, when we do get stuff unsealed, we'll share and publish the records that we get via FOIA and via this court case, and then we'll dig into them to see what we can see. What happens next in this case? The judge hasn't taken any action on our petition yet in the months since we filed it, but the local U.S. Attorney's Office has filed a statement of interest saying that they want to be involved in the case because, of course, what we're asking for involves their surveillance requests. We welcome participation by the government in this unsealing process because they're the ones who are in the best position to know which of the investigations that are affected by our request are still ongoing. They may have their own system for keeping track of these surveillance orders that would make it easier to track them down than the court system, and they'll know whose names need to be redacted when records do get unsealed because they're confidential informants, etc. So they're in a better position to resolve a lot of these details than the court. And we hope we can work with them to figure out what the best and most workable process would be for unsealing. Courts tend to prefer it when the parties work something out between themselves. I don't know if the government will be receptive to a collaborative process. Before we filed the petition, we approached them about it and they weren't really responsive, but now that we're actually in court, I'm hoping that we can confer productively with them. If there is a conflict, I think it'll be if the government wants to protect its investigative methods and techniques. In other words, to hide the novel technical assistance that it asks for, and how it uses the law to compel companies' help in monitoring people. They might argue that if the public knows what it's doing, then criminals will be able to avoid that surveillance. But that's exactly what Jennifer and I think the public needs to know in the encryption and surveillance debate. So like I said, we're planning to analyze documents we receive, and our hope is that that will provide a clearer picture to the public of exactly what law enforcement, particularly here in our home in Northern California, has been up to when it comes to surveillance and forcing third parties to assist in police investigations. And we're hoping that that will inform the larger conversation that's going on about what investigative tools police should have in the digital realm and whether they're exercising their power wisely and what the proper public policy is for government access to encrypted information. We're really pleased to have been able to pursue this work over the last year, and to continue it for the next year. So like Barbara said and like Jennifer said, thank you for joining us today to learn more about how CIS is working to promote transparency and better public understanding of the current crypto war. And we're happy to take questions. We have mics to either side.
Thank you. Please just line up and we'll go back and forth for people who have questions. Hi, Peter.
Hi.
Hi.
I have a brief comment and a question for you. The brief comment is that I want to applaud you all for organizing this thing. The problems that we're facing require a tremendous amount of synergy among the law, the technology, the policy, and the recognition of all of the risks that exist. My poster child for that was Ed Felton, who spent quite a bit of time at the Stanford Law School. He's the head of all of the security stuff at Princeton. He also spent a year in government. So here's a guy who has been able to do everything. In this case, you have all of the people in Stanford who can pull together, but you've got to really pull together.
Yeah. And do you want to say a little bit about your work in this issue? And
well,
for people who don't know, Peter Neumann?
I think you'll get, I'm at SRI, formerly Stanford Research Institute, across the road here. My question starts out by pointing out that there's one thing that you fundamentally have completely ignored, and most everybody else does as well. And that is that essentially every computer system today is broken. There is no sense of security. So trying to put good crypto into a system that is already broken is inherently problematic. Now, it's not just the systems that are on the internet. You remember that we still have systems with dial-up phone lines. If you can get in, you don't need the internet. And if you go back to the Stuxnet centrifuge problem, you don't even need a connection to anything. This was a sneaker-net connection where a little social engineering got somebody on the open side to carry a dongle or something into the controller for the centrifuge and wipe out some of the centrifuges. So the fundamental problem that you need to also recognize, and I want to ask you the question of how do you confront that, is that everything today is already broken. And the idea of the government going to Apple and saying, hey, we want you to create a new operating system that will allow us to do this, and spend $1 million on finding a hack that would do it, was ludicrous, because all of the systems that we're dealing with at that point were fundamentally broken. And even the new phones are having similar problems. So how do you deal with that from the point of view of the law in the absence of the technology that enables you to have any sensible understanding of what's going on?
Yeah. So let me be a bit provocative about in my response to you, Peter, and see what you and others think about this. I think that the idea that everything is broken is very much a technologist's idea. And the idea that things are insecure because there are all these different ways that somebody can get access to the system and control it or get access to data. But from a policy perspective, we're willing to deal in a much more imperfect world. It's not all secure or insecure. The question, I think, my approach to it is can we make it more secure? Are we on the arc towards security, or are we on the arc away from security? And one of the big issues there as it relates to government surveillance the question isn't, can we make it secure from governments? Because as we saw with Stuxnet, and as you see with the disclosures about NSA's capabilities in doing government hacking and that sort of thing, governments can be really, really good at this stuff. And the systems are also broken. But I think one question is, can we make it more expensive? So it's not just a free-for-all, but it actually takes some time, some money, some attention, some effort. And the reason why it should be more expensive than it is because we want governments, surveillors, to have to make some choices. You know, we don't want it to be cheap and easy to spy on everyone. We want some decision-making going on there where it's like, we're going to spy on the people who it's worth it. And so, you know, as we make things more secure, if there is encryption, even if the system is broken, it makes it that much harder. And if it's that much harder, it means it's not like an opportunistic, suspicionless collection. You have to try. That trying, I think, is a feature. And so that's what we're trying to build in, even if ultimately the trying might be successful. And I think that's the argument that some of your I'm not saying I agree with this argument, but I think that's the argument that some of your colleagues on the Keys Under Doormats paper have said in the context of government hacking. Let's be realistic. There already are backdoors and everything. That's the way we build it because we suck at security. So why don't we just use that instead of trying to legislate making it worse?
Great.
So, you know, but nevertheless, I think those authors and I would say that doesn't mean we don't try to make things more secure, because the opportunities for surveillance because of that and security are still so big. We try to like slowly work towards better security. Maybe someday there will be a world where things are so secure that law enforcement can't get in, and that's a problem, but we're not there yet.
Okay, that's a good answer, but you asked me to mention a little bit of what we're doing. So let me shoot myself in the foot by saying that we are building for DARPA an open source, clean slate architecture, hardware, new hardware, new software, new programming language extensions, new compilers that understand the hard way and prevent you from making all of the errors that most people make. And even if we had that, and it's widely deployed at some point in the future, it's not enough. Because there's social engineering, there's insider misuse, there's denial of service attacks. We just saw this monster Internet of Things or misthings or whatever you want to call them, used as zombies in a denial of service, a monster denial of service attack. This is all trivial to do. The folks who did that, whoever they are, used one of the two major malware packages where you just turn the key and you put in parameters and trigger it, and it works. It's no big deal. So even if we are successful in doing what we're doing right now in the open source world, and it's widely deployed, it's still nowhere near good enough. So it's the old story. The enemy is the best is the enemy of the good. We're building the best we can do, and it's still not good enough.
Yeah, thank you. Other comments or questions? Let me ask the audience and see if anybody. Yeah, Dan, please. Well, yeah.
I'll ask a question.
Professor Bonet.
I guess it's also good to remember that our homes are not perfectly secure, right? Our homes are pretty easy to get to break into, and yet police doesn't break into our homes without permission. So we can live in a world where our computer systems are not perfectly secure and still have limits on surveillance. I guess the question I had was a little controversial in this audience. We're all on the same side, but I'm wondering, is there a way to kind of change the conversation from being more confrontational to being more helpful? So is there a way that we can kind of address the legitimate needs of law enforcement in the 21st century and yet kind of satisfy the privacy requirements? So one area, for example, that is ripe for collaboration is the area of education, right? We can help educate law enforcement officers about technology and how it works and so on. Do you see other areas where we can actually collaborate and just kind of have a constructive conversation as opposed to being on different sides?
Yeah. So, Dan, I know you've been involved in some of these conversations, right, with law enforcement about what these sorts of collaborations would look like. I think there's certainly a lot of room for education. I particularly see it on the part of legislators and judges. I think it's very hard sometimes to understand. It's hard to issue spot, never mind, figure out what the answer to the issues are. I hope things are better today than when I got started in this business. Back in 1996 or 97, I had a case for a computer hacker, and the evidence that was admitted in court against him was a log of access to this particular computer, but they had basically taken only the times where there were accesses from his computer and basically cut out of the log all of the other accesses that might have happened, and then just gave it to me on a printout. And I asked for the original data, and they didn't have the original data and didn't want to give it to me. And I told the judge, you can't, trust this thing. This is basically just cut and pasted. And the judge said to me, you mean like with a scissor? And I was like, I'm going to lose this case. So, I don't think we're still there, but we do have a long way to go to understand. I think that education in some ways has been working in the context of the encryption policy debate, because I think that I guess I thought this in the 90s, so maybe I'm wrong, and we're just sort of like going to bide our time. But I think that there is increasingly a realization on the part of law enforcement that encryption is an extremely valuable and important tool for preventing crime, and that we can't really have it both ways. Policy people, lawyers, we always like to have it both ways. You're a little unhappy, I'm a little unhappy, we won, But in the technology world, and Dan, I'm sure you guys are going to talk about this in the next session, that's not the way it works. It's like, you're a little bit unhappy, and this guy figured out how to make us all really miserable, right? So we're trying to avoid that. And I think there's this realization. Some of that is education. I think some of that is politics, as the Federal Trade Commission, Federal Communications Commission, or the Commerce Department get involved. I think these other values are there. But I do think there's a lot of politics involved in this, and where there's politics, I think sometimes the actual policy stuff can be muddled or unclear in the interests of kind of winning the game and getting where you want to go and sort of achieving your outcomes. And let me give you an example. You said our homes are insecure, but the police just don't go breaking into them, just because of that. And yet these are the arguments that we see in computer cases. There was a court, I believe it was the court in Virginia, in one of these, in one of the cases involving a child pornography ring, that said that people don't have a reasonable expectation of privacy in their computers. And you don't have an expectation of privacy in your computer because everybody knows that computers are really insecure. So how could you ever expect that anything you do on your computer would be private? And I'm not talking about like in the cloud or on Google or Facebook. It's like the stuff you do on your home computer. And so since you don't have a reasonable expectation of privacy, the Fourth Amendment applies. And since the Fourth Amendment doesn't apply, the government doesn't have to go and get a warrant. So it's very hard to, sort of think about what the educational opportunities are there, because in the way that these cases are actually being decided, the government's got a guy who is a child pornographer that they want to put in prison. And that's important. That's a really important value. And on the other hand, we have the potential for a rule that says governments can hack computers without warrants all the time. And that's terrible too. And so those are the kind of conflicts that I think that we're dealing with, and in many ways they're like a power battle more than they are a education thing. So I'd be curious what your response is to that, because here I am teaching at Stanford Law School and saying education is going to have a limited effectiveness on helping us resolve some of these problems, but I do in some ways think that's true. Yeah. Bob, do you want to?
Okay. This is kind of an open-ended question. I'm wondering what you think the international implications of this debate are. Are we likely to get to a world where there are two tiers of products? There are secure products in certain jurisdictions and insecure products in others. That may not be the most interesting international question, but talk about the international problem.
Do you have thoughts about that?
Sure. I mean, the two-tier system is one that we've seen before during the 90s when there were tighter export controls on encryption products. At that time when you were going to go download the then current version of Netscape Navigator to browse the internet, there was one for U.S. residents and one for international residents, which had weaker crypto than the U.S. one. And you were just supposed to, be on the honor system if you were outside the U.S. and pick the one with the weaker crypto. And that was how we did things. And it was certainly a choice that some companies made to provide two different versions of their product. I don't know whether that would happen in the present day. It's certainly possible. It's also possible that some companies might choose to make one weaker version of the product, or might decide not to enter or to exit the market entirely. Jennifer had mentioned earlier that it's possible that we would just see, a move from one jurisdiction to one with friendlier laws to use as a home base, given that it's sort of hard, I think, to pretend that people won't have access to the stronger version of a product. It wasn't realistic with Netscape Navigator. It wasn't realistic with PGP being put out over the internet when that first came out, and it was immediately available for download around the world, and I don't think it would necessarily be reasonable today. One thing that I think might be a focal point, and that's something that Nate Cardozo from EFF, who's here today, has mentioned, is that it might be a move towards saying, what is the default setting in a product going to be? If we could build strong crypto into this product, but make it buried 3 menus in and make you have to jump through a bunch of hoops to configure it to be optimally protective for you, that might be something that could be something that law enforcement by and large are happy with, because they realize that most users aren't going to change the default settings on their products, but that might still offer sort of this fig leaf of saying, oh, but it's still there if you look for it. So that's one possibility.
Just to follow, do you have any sense whether the EU is interested in your work? Have you ever?
I wish I were important enough for the EU to care about my work. We've seen a lot of differing opinions. I don't know that there's anything sort of at the pan-EU level, but there's a lot of dissent among different countries within the European Union right now. On the one hand, you have the Netherlands, who said we're never going to pass legislation that advocates for backdoors or weakening encryption because we recognize the benefits of strong encryption. And on the other hand, you have countries like France, where largely driven, I think, by recent Islamist extremist problems in their countries that have caused them to sort of retreat somewhat or be in tension with the strong data protection prerogatives that most countries like Germany or France in Europe have, where they're saying, maybe it would be a good idea to try and backdoor things. I think I just saw a headline about a court in Belgium saying that Skype has to backdoor their system under Belgian law, and I've seen some suggestion that that court decision even was sort of driven by being influenced by the problem of Islamist extremism in Belgium. So I think,
It already has.
yeah.
It is backdoored, but
Well, yeah, Jennifer had mentioned earlier on about Skype in the U.S. But I think that for all that the EU seems to try and do things top down and then have things implemented country by country, we're seeing a lot of differing opinions within the EU, and it's my hope that, like I mentioned, because they do have very strong protections for people's personal privacy and personal data, that might end up leading towards saying we're going to vouchsafe this in our law and not let our fears around terrorism lead us down the garden path towards backdoors.
I would just add to that, we have seen some push for this in the UK Investigative Powers Bill, where there's some pretty broad provisions asking for provider technical assistance, which can be compelled with like a letter from a secretary or something. They have a different kind of system. Judges don't issue the orders, and that's can be scary for 2 reasons. One reason is when these demands come about, there's the chance that it's a lowest common denominator thing. In order to make a product that complies with Belgium law or with US law, then there will be a crypto backdoor for products that are sold in every country, even those where there's not rule of law or there's a bad human rights record. The other thing is that increasingly we're talking about cross-border data sharing regimes outside of the way we've done it in the past, and having some special relationships with certain countries, including the UK, whereby providers could comply with UK-issued orders for surveillance. And so if you're thinking about having those special relationships with European countries, and they're going to have these expansive technical assistance provisions, and then they're going to say, okay, well, our process is approved, this idea that you have to help us do this surveillance, and it could be one of these novel kinds of surveillance that maybe has security impacts, now what are you going to do? We don't have the traditional mutual legal assistance treaty process operating then if we enter into these agreements. So there's a real concern that, it's technologically a race to the bottom for business reasons, or it's legally a race to the bottom, it's a race to the bottom also for legal reasons. I think that's another problem. It's different from service to service. There are some services that are easy to provide a different experience for people in different countries, like Google.fr or something like that. But it really can be a disaster for a company like Apple to have to sell a different kind of iPhone in different regions. So I think that we will see companies probably split in terms of who's willing to put a foot down and say, like, we can't do it this way, depending upon what their business model, what their product is and what their business model is as time goes on. Yeah. Thanks for the question. Hey, Mark.
Hi, Jennifer. I'm Mark Seiden.
Last question, because we're a little bit over. Sorry about that.
Well, I hate to defend child pornographers, but this is just another example of forbidden knowledge that is of interest to the government. It might be ISIS recruitment videos, it might be child porn, it might be malware, and the point is to try to find this content in our communication. I would prefer to say the government is interested in child pornographer. I would prefer to rephrase that as the government is interested in someone who's looking at photographs of certain kind of forbidden content. And there's very little, the question of is it pornography, is it a child, is often not known at that time. There's a lot of nuance in these cases. I've worked on quite a few child porn defenses just to figure out what happened. And the policing is remarkably bad. So I would recommend taking a nuanced approach to this along with everything else.
Yeah. Thank you, Mark.